From the daily list, item number 1.
My lords, this matter relates to public interest litigations for the congestion or traffic problem in the city, Shillong City, my lord. So far as state is concerned, my lord, they have filed almost 8 reports till today. 8 reports, 8 status reports. And in the last occasion, my lord, this court allow us to file a reply. And we have reply in response to the last reports. And there, my lord, the government has made the decision that they are forming the Shillong Decongestion Committee, comprising of the officers, my lord. Their suggestion is, my lord, we put forward a suggestion to the government, subject to the lordship approval, that we have seen the members of the decongestion committees. These are all the government officers who do not come from the, my lord, the town planning backgrounds. So we are suggesting 2 persons, particularly who are a retired person and who has expertise in the, my lord, town mobility and town planning, my lord. So that is one suggestion. Another aspect of the matter, my lord, if I take the latest report by the government, my lord, the latest report of the government, date is, my lord, they have filed on 14th November 2023.
Which page you are reading, sir?
My lord, the last report dated, my lord,
Report is dated
14 November 2023.
14th November.
Ma'am.
This one? Page 2.
My lord, the page number 1, my lord, para 1A, they have highlighted, my lord, the Shillong Decongestion Committee.
Page number?
Page number 1, my lord, para 1 of the report dated 14 November 2023. Well, in lordship, may kindly see there, they mention Shillong Decongestion Committee. My lord, it will be the first page or the next page.
14 November, yes.
There the officers, they have mentioned there, my lord. According to me, my lord, here, therefore we make a suggestions. The members mentioned therein are only government officers, my lord. It requires, my lord, a person who has expertise in the town planning, mobility, so that they will give a valuable suggestion, advice to the committee, so that committee can move forward. That suggestion, my lord, I have taken in my affidavit, respond to this one. So if lordship will look to my affidavit, my lord, the reply affidavit. I have filed my reply affidavit on 15 December 2023. 15 December 2023.
December. The order.
That was.
Yes.
My lord, in paragraph 5 of my affidavit, my lord, may go straight to page number 7. I have suggested 2 persons.
1 minute, sir.
Yes.
Page 16. Yeah.
Paragraph 5, my lord. In response to the Decongestion Committee.
Yes.
My lord. There, my lord, I come to the next page. I have mentioned, my lord, Dr. P.S. Nailang and Mr. Shri Penskam Susni. They are, my lord, in fact, expert in the town mobility, in the field of town mobility. So for your lordship consideration, this is my suggestion, my lord. And other aspect of the matter, the entire reports, my lord, it's the repetitions of the report one after another. And in the ground reality, my lord, it is remained unchanged till today. And in the last occasion, my lord, the government also submitted that with regard to decongest the city, measurement with regards to the accommodation to the hawkers, the vendors, is one of the major challenges. And for that, my Lord, if Lordship allow me to suggest, Lordship may direct the government to come up with the concrete reports as to how many location has been designated as a vending zones. Because the state has adopted the central legislation.
So according to the encroachments also there.
My Lord, encroachment is not there. The problem with the government is, my Lord, under the Act, government has to identify a certain area as a vending zone. And they will allot to the vendors. Vendors will pay certain taxes to the government. Government will generate some funds. And so as to ensure that vendors also have certain degree of dignity of their profession for their livelihood, and can bring convenience to consumer also. And major one is, my Lord, this would really ease the traffic congestions, my Lord. So to do that one, my Lord, the first duty of the government is to identify the vending zone. Now, as till today, my Lord, we don't know, my Lord, in the entire city, how many vending zones has been identified. If I'm not wrong, in other related petition, the other age said.
Yes, my Lord. Now, my Lord, so far as vending zone is concerned, first issue is, my Lord, for vending zone, there was an issue with regard to the State Act and Central Act. We have adopted Central Act, and in terms of Central Act, my Lord, requirement is to create vending zone in different parts after carrying the survey, my Lord. We have carried out survey in certain regions. Their local darbars, there was some opposition in local darbar. In fact, writ has also been filed, which is pending for learned single judge. But we are creating vending zone. We have carried out the survey to identify the vendors. We will give the registration. We will create vending zones. We are working in those directions. I can file a detailed status report, placing on record the steps taken to carry out the survey so that we have vending zone.
So if the vending zone is created and persons are shifted,
yes, sir.
It's easy for you to clear the
yes, Sir Lordship. That is one issue which is highlighted, where we are trying to, because livelihood issue is also there. At the same time, what is happening is that those vendors who are there for quite some time, we have to shift them. We have to then. Recently, a writ petition was filed by those schools, etc., that you should not create vending zone in my area because this is the area which will get disturbed because of vending zone. All those kind of local pressures and protests are also there. We are working out. We are convening meeting, and we are very keen to have vending zone, and we will do it, Milord. And I can place the report also.
So how long it will take?
It will, Milord, I have to take instruction because this vending zone was also part of separate PIL, Milord, and separate issue. I will take instruction and I will place the report, latest report, what is the status and how much time we will be needing to do that.
When do you want?
Your Lordship may have give 2 weeks time. We will do it in 2 weeks time.
No, when the matter is taken up for hearing, the counsel appealing for the respondent would submit that team will be constituted for the purpose of identifying vending zone and accommodate the genuine persons in that zone, and further action would be taken in order to give a quietus to the issue on hand. The counsel also submitted that he requires 2 weeks' time to file a detailed report and the time that may be required for the purpose of identifying the person and allot them the places in terms of the provisions of the Act. At the request of the counsel for the respondent, post the matter after 3 weeks. AG. 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 Yes.
Deeply obliged.
3 weeks.
Obliged.
Item number 2.
My Lord, in this matter, Lordship, sir, this one could allow me to file an affidavit in response to the application filed by the state seeking for implement of a third parties, my Lord. Lordship, allow me, we are in the process of filing today itself. And may I pray matter may come up after 10 days, if Lordship permits.
Sir?
Lordship may give me 10 days, my Lord,
What
We are
time?
filing our response today. We are in the filing process today, and matter may be heard after 10 days.
Request of the appellant was the matter after 2 weeks.
Yes. Hello, Mr. Give it.
Item number 3, 5.
3 to 5. Connected. Yes.
May please, Your Lordship. This is an appeal, my Lord, against the conviction. 3 persons, and this is one of the appeal. In this case, my Lord, the trial court have failed to do according to law. They have not complied with the law. It's non-compliance with the law. I'll come into all those points one by one, my Lord. First foremost, my Lord, the FIR is at page 5, my Lord. Not hearing.
Yes. Ready? Ready?
Lordship, yes.
We can take up the matter finally. We can take up the matter finally.
Yes, my Lord.
Today itself.
Yes. Immediately, of course, Your Lordship is come. Yes,
Today is
please.
also an auspicious day for us. So you want time? You have to tell us. You are ready, we are ready to take. The whole day is before us.
We'll start, my Lord. We'll start it.
What is it?
We'll start.
Start means you have to conclude.
It's okay, my Lord.
So you are also ready with the authorities and
Lordship, yes.
yes. Yes.
The FIR, my Lord, is at page 5.
Yes. Yes.
Can I read it? May I read it? To the IC, PI, Police Investigation Center, Natyam, to arrest those named below. Dublin, Charmang, Mud Rakai, Thum Rakai, Mudo Rakai, Yola Rakai. Sir, I, Srimati Sharbi Rakai, Natyam, mother of Sri Salon Rakai, who was murdered, humbly request you to arrest those persons that was named in the subject above for the reason that they have murdered my son, Sri Salon Rakai, in my residence in Nartiang at 7 p.m. on 10/7/2006, madam. I cannot come to report the matter before you since the murderer prohibited me to inform you. They threatened to kill me as well. I'm just a powerless woman. I pray before to ask them to cremate and collect dead body as I'm unable to do it myself in the future to protect me from this cruel person. I will be forever grateful for their kindness. Thanking you, yours faithfully, Srimati Sharbi Rakat, non-room. This is FIR, my Lord.
Yes.
So in this case, my lord, a charge was framed. The charge was framed under section 302 plus 34 IPC against all the accused persons, my lord. The records show that the accused person is at page 26, my lord, the charge, at page 26. 26 of the paper book. The typed copy is at page 27.
Yes.
The typed copy is at page 27, my lord. Here, my lord, Trinity B. Kelly, Session Judge, President Tahir District, hereby charge you, Mud Rakai, Moina Pale, Mulo Rakai, Thum Rakai, Yola Rakai, Director Man, that all the five of you as follow, always be an opportunity, Natiang, that you on or about the day on 10/7/2006 at 7 p.m. when and mother Salon Rakat, son of Sharbi Rakat, in the residence at Natiang, and thereby committed an offence punishable under section 302/34 of the Indian Penal Code and within the cognition of this code, and I hereby direct you be tried by the said court and the charges. The charge read over and explained to the accused by Shri R.B. Hing, advocate in Penar language, and accused Mulo Rakai, Yola Rakai, Mud Rakai, and Thum Rakai pleaded guilty, my lord. While accused Dilip Sharma pleaded not guilty. In the last line, charge read over and explained to the accused by Shri R.B. Hing, advocate in Penar language, and accused so and so, they have Mulo, Yolang, and Mud Rakai, they pleaded guilty, while accused Dilip Sharma pleaded not guilty, madam.
Yes.
Now, my lord, I'll come to page 17 of the paper book, my lord, because my first contention, my lord, is that all the accused, my lord, are illiterate and poor person. Are illiterate and poor person. Page 17 of the paper book, my lord. In page 17, my lord, educational qualification in 11B, illiterate. And in income group, my lord, they are of the lower income group, below rupees 500 per month, my lord. So these appellants are all illiterate and poor. My next point, my lord, is that regarding they are illiterate and of the lower income, that it comes to the point, my lord, that this charge, my lord, when it was charged, when it was framed, they were not explained, my lord, to the accused person. nowhere in the record is shown that have explained to them, to the accused person, my lord. There is no explanation regarding charge to the accused person.
Yes.
Then, my lord, they have written, in the charge, they have stated that one, the defense counsel is the one who read about and explained to the accused R.B. Hing, my lord, in Penang language. My point, my lord, is that this defense counsel, my lord, who did the part of interpreter, they have not do any oath. There is no oath or affirmation that they will do it correctly, my lord. There's nowhere in the record to show that oath or affirmation was done by the interpreter, my lord.
See, already confession statement is there. The confession statement was put by the court to the accused.
That,
In the court, before the magistrate, it has been accepted.
my lord,
One person has denied it, and it has been categorically stated that accused pulled the person on the road and killed him using hammer and other dangerous weapons. What else do you want?
no, my lord, I'll come step by step. First, I'll deal with the charge, how it was done. The charge was not done correctly, my lord. There is no interpreter. Nobody explained to them regarding the charge. I can deal all those allegations, my lord, regarding that confession.
Yes.
Then, my lord, oath or affirmation was not done by the interpreter. The law specifically required that it should be done.
Under which language he has got to be informed?
Regarding the submission of the
PNR. Local language. PNR. No. The Penang language.
yes, in front of
It's got to be explained.
Yes,
You
we
have got to be informed, is it not?
yes.
You take page number 43. Take page number 43.
Yes, my lord. This is a confession. I'll come to that also, my lord.
So it has been explained in the local language to the person.
My lord, first and foremost, when they framed the charge, nobody explained to them. Nobody explained to them, my lord, regarding the charge. Nobody.
Yes.
It's on record. There's no explanation.
Yes.
And over and above also, they see that was an interpreter is that defense counsel. No oath or information was done to him as that interpreter, my lord. My lord, I rely also on the decision of the, as far as that part is concerned, my lord, I rely on the decision of the Honorable Supreme Court in Khulam Hassan versus Muhammad Makbul Makri, as reported in AIR 2022, Supreme Court 5454, my lord. Paragraph 27. Para 27, my lord.
Yes.
It is evident that the trial court is enjoined with a duty to apply its mind at the time of framing of charge and should not act as a mere post face. The endorsement on the charge sheet presented by the police as it is, without applying its mind, and without recording brief reason in support of his opinion, is not countenanced by law, my lord. It's not countenanced by law. So this portion, my lord, the trial court which convicted him has not followed, my lord. In Para 27, it is very clear. It's evident that the trial court is enjoined with a duty to apply its mind at the time of framing of charge and should not act as a mere post face. The endorsement on the charge sheet presented by the police as it is, without applying its mind and without recording the brief reason in support of his opinion, is not countenanced by law.
Yes.
There is nothing on record to show, my lord, that there is a recording of brief reason in support of his opinion. There's nothing, my lord.
Yes.
Because the court must be satisfied that evidence collected by the prosecution is sufficient to presume that the accused has committed an offence, my lord. Now I'll deal, my lord, with the 164, my lord. Now, my lord, I'll come to the deposition of PW7, my lord, at page 42, my lord. PW7.
One minute. This is not the case where the accused have confessed before the magistrate, agreed, accepted. It's a distinguishable one. Yes.
At page 42, my lord, is the statement of
Which page, sir?
42 of the paper book.
Yes.
I joined service in the year 2002 and presently posted at East Gentile District as Additional Deputy Commissioner. In the month of July 2006, I was posted as EAC Magistrate First Class in the Deputy Commissioner Office, Eswal, Gentile District. The case was endorsed to me on 12/7/2006 by the learned ADM Sri F.M. Dub for recording the statement of the accused person, Mur Rakai, Muro Rakai, Tom Rakai, and Yola Rakai, under section 164. I fixed the case for recording of their confidential statement on 13/7/2006. I remanded the accused person to 1 day judicial custody since I seen that the accused were brought from police custody. On 13/7/2006, the accused person was brought before my office chamber around 10:30 a.m. to 11 a.m. Then I explained the accused person briefly the procedure for recording of confessional statement, and then I sent them back for 2 hours reflection time, and were sent back to the PI room. And I have also sent my attached peon to accompany them and to be with them. Then the accused person were brought before me in the afternoon at around 2 p.m.
Yes.
Each accused was brought to me to my chamber one after the other, and I recorded statement individually. From that statement of the PW7, my lord, the person who recorded the confession, my lord, it clearly showed that 24 hours was not given. The Honorable Supreme Court, my lord, in the case of Sarwan Singh versus the State of Punjab, at page 45, my lord, of the citation we have, page 45.
Is the citation?
At page 40, Sarwan Singh, my lord.
Ravindra Kumar.
No. Sarwan Singh. Ravi Kumar, I'll come later on, my lord.
Yeah, 1957.
1957. Supreme Court Report 953. There they have stated clearly at page 45 that they should be given at least 24 hours. And they should be sent to jail for reflection before the confession, my lord. In Sarwan Singh, my lord, when an accused, in para 1, when an accused person is produced before the magistrate by the IO, it is of the utmost importance that the minor accused person should be completely free from any possible influence of the police, and he must be sent to jail custody and given adequate time to consider whether he should make a confession at all. Ordinarily, he should be given at least 24 hours to decide, my lord. In this case, that was not done. That was not given.
Yes.
It is on record that it was given only 2 hours, my lord. That is from the time factor, my lord. And another thing also, my lord, they should be free from the police, from any police influence of the police, and he must be sent to jail custody. That was not done, my lord. They was not sent to jail custody. They was not given 24 hours. So he is clearly hit by this decision, my lord. He has clearly stated when an accused person is brought before the magistrate by the IO, it is of the utmost importance that the minor accused person should be completely free from any possible influence of the police, and he must be sent to jail custody and given adequate time to consider whether he should make a confession at all. Ordinarily should be given at least 24 hours to this, but in this case was not given. On the other hand, my lord, they sent them to the PI, my lord. And in July PI room, there are not less than 4 or police. Because at that time there is no separation of judicial, ST and judicial. So it was done together. So there are not less than 4 or 5 police in the PI room, my lord. That it is not denied also by the.
Yes. Your contention is accepted, everyone should be granted bail, and after some time only we can take it. Then they will flee, then the police will have to send a team to search for them. Then we have to take another action saying that he jumped the bail, conditions, cancellation of bail, etc. Yes.
That is a technical aspect only, my lord. But the fact remains that a person will be convicted for life is quite different from the when there is a on the face of the record it's clearly shown and the non-compliance of law and the non-following of the decision of the apex court, my lord.
Yes.
And another aspect also, my lord, is that in this case, Kirby 7 has clearly admitted in page 45.
$25.
45, my lord. 45.
45.
Yes. In the cross. Last paragraph, my lord. Cross by Shri R.B. Hing, Defense Counsel for the accused person, Mulwarakai, Thumrakai, and Yolan. It is a fact that in the PI room there were police personnel present at the time when I sent the accused person for reflection. It is not a fact that while recording confidential statement of the accused person, no one was in my chamber except the accused person individually. That means in his room also there are other persons also. Then it is a fact that I did not make a memorandum at the foot of the confidential statement recorded, but I have written ROAC below the confidential statement. So, my lord, the memorandum of confession as laid down in the CRPC also was not followed, my lord. In 164, my lord, in 164, paragraph 4, my lord, of the CRPC, it has clearly stated, any such confession shall be recorded in the manner provided in section 281 for recording the examination of an accused person and shall be signed by the person making the confession. And the magistrate shall make a memorandum at the foot of such record to the following effect. I have explained that he is not bound to make confession, and that if he does, any confession he may make may be used as evidence against him, and I believe that this confession was bluntly made. He was taken in my presence and hearing, and was read over to the person making it, and admitted by him to be correct, and it contained a full and true account of the statement made by him. This was not done, my lord.
Yes.
So if this was not done, my lord, then there is There is no 164. There is no confession.
See, now according to you, you have not denied the incident. The incident happened. Only thing is, on technicality, you say that they have not been properly informed in local language. Even if page to page, the court has recorded that the local language, the conversation took place. Even the last line, from first line, it is there, the last line is also there, page number 5. Inner page 5, page 46.
This is not a fact, my lord, that I have admitted regarding the incident also. I nowhere I have admitted that the incident. And there is none of the witnesses also stated that I have committed the murder. None.
Yes.
None, my lord.
Except this statement before the court below, according to this independent evidence wherein they have denied the charges.
Yes.
Where are they?
The only one they deny, my lord. The rest they didn't deny because they don't understand, my lord. They don't understand. They are illiterate. They don't understand. No education, and they are poor. They have no education. They don't understand, my lord. It is on record. They are all illiterate. There is no words issue that they understand there.
Yes.
The question, my lord. I'll refer also, my lord, to the citation, the law laid down by the Supreme Court in the case of Sipapa versus State of Karnataka, as reported in 1995, 2 Supreme Court cases, page 76, my lord. In my compilation, my lord, is in page 1, and the operative part is in page 3, my lord. In the last portion of paragraph 7, my lord, as stated, the magistrate was entrusted with the duty of recording confession of an accused coming from police custody or jail custody must appreciate his function in that behalf as one of judicial officer and must apply his judicial mind to ascertain and satisfy his conscience that the statement that the accused make is not on account of any extraneous influence on him. That indeed is a voluntary statement within the meaning of the provision of Section 164 and the rule framed by the High Court for the guidance of the subordinate court. Moreover, the magistrate must not only be satisfied as to the voluntary character of statement, he should also make and leave such material on the record in proof of the compliance with the imperative requirement of the statutory provision as would satisfy the court that sit in the judgment of the case, that the constitutional statement was made by the accused voluntarily and the statutory provision was strictly complied with. There is nothing on the record, my lord, regarding this. Nothing.
Yes.
Now I'll come, my lord, to another law laid down by the Supreme Court. This, of course, by the High Court of Andhra, my lord. Yeah, 1956. By the Supreme Court, my lord. Yeah, 1956.
Yes.
Supreme Court 217. The magistrate entrusted with the duty of recording the confession of an accused must satisfy himself with his conscience and that the statement accused person was going to make was not on account of extraneous influence on him. Raja. Raja.
The judgment is also against you. The
No,
judgment is also against you.
no, my lord, it's not against me. There's nothing, nowhere is against me.
To allow a man to be convicted on the strength of a confession statement unless it is made voluntarily and unless he realizes that anything he says he may be used against him. Next is very important. And any action by a person or authority to bully a person so and so, then the court has held that the person should be put on notice. That if you make the confession, it will be put against you. That has been done at page number 45 for the lower court. I have also briefed him that whatever confession he will make, the law will take its own course and the statement should be voluntarily.
But in 164, my lord, it is very clear that it should be, that paragraph 4 is very clear that it should be done according to this form. I explained to him that he is not bound to make confession and that if he does so, any confession he may make may be used as evidence against him.
Correct.
And I believe that this nowhere, my lord, is there.
There, page 45. It's a different terminology they have used, that's all. Suppose we reject your case. Some judge may say rejected, some may say dismissed. So the result is one and the same. The meaning is one and the same. Yes. Next point.
I have emphasized also, my lord, that in this case there is no eyewitness.
No?
No eyewitness.
No eyewitness.
Yes. It was solely based on the confession, my lord. That is clearly stated by the court, the trial court. Page 220, my lord, of the judgment, my lord.
Yes.
Two 20. 249. In paragraph 126 of the judgment, my lord, in the instant case, it is clearly evident that there is no eyewitness to the crime. Though previous one provided evidence that it was the accused person who had pulled the deceased out of her house on the night of the incident. The instant case is heavily reliant on the confidential statement of the accused person, which found corroboration from material and medical evidence. To recapitulate the same, the following arrest may be stated. This is what the trial court stated, my lord, but there is nowhere to show that there is any corroboration, and it is on record also that she has admitted there is no eyewitness. In paragraph 126, my lord.
Yes.
I'll come, my lord, to the paragraphs 110 at page 230 of the paper book.
230.
230, my lord. Paragraph 10. Where do you want to confess? Ruling? Paragraph 110, my lord. From the above evidence,
Page?
230,
Yes.
Yeah.
There are 110.
110.
Yes.
From the above evidence of the IO, it is seen that the material seized were never sent for forensic examination. In spite of the fact that the material exhibit one big stone was said to have blood stain on it. Since their material were found near the dead body of the deceased, it is evident that there was no attempt to cause the disappearance of the material. Thus, there is no information whether there was any fingerprints or any other object on the seized material. So, my lord, there is nothing to connect the appellant and the crime, my lord. Also, it is seen that IO has not prepared the sketch map of the PO.
Yes.
Also, it is seen that IO has not prepared the sketch map of the PO or took any photograph of the PO or the material seized. The IO, after thorough examination, was unable to know who was the first accused who attacked the deceased victim but only went on to make a blanket statement that he knew that all 5 of them were involved in assaulting the deceased, which led to his death. In this case, my lord, it is on record that it is on the road. How can it be there is no eyewitness? No eyewitness and no photograph, then no soil sample, whether it's correct or not, nothing. Sample from the place of the occurrence, nothing, there's nothing on record to show that. Rather, he stated that IO, after thorough investigation, was unable to know who was the first accused who attacked the deceased victim. That means clearly show, my lord, that it's only a presumption. It's only presumption that this appellant are involved in the crime, my lord. Otherwise, there are no evidence against them. Then the last performance, then the trial court stated that apart from the normal routine step of investigation, it is nowhere seen that IO was proactive in carrying out the associated step to strengthen the prosecution case. It is understood that IO has placed great reliance on the fact that there is a confessional statement of the accused person which could prove the case. But the confessional statement, my lord, on the face of the record is not correct, my lord. Why do you want to make confession?
Yes.
And then continue with that, my lord. Regarding the seizure, though IO has stated that the accused person was also present at the PO, they were the one who had shown him the murder weapon, but he has not mentioned it in the CD. So there's nothing to mention that those material exhibits belong to the accused person, to the appellant, my lord. Over and above, my lord, the seizure witness are police, my lord. In spite of the fact that they say that it happened on the road and they have come in the daytime, the next day, they say that the seizure witness are the police themselves, my lord.
Yes.
My lord, I reiterate that there is no confession. So I'll rely here also in the case of that Rabindra Kumar, alias Dara Singh, based on Republic of India, my lord, in Supreme Court in 2011, 1436, in para 28, my lord. In my compilation is in page 26, my lord. Para 28 is in my compilation is 26.
2011.
2011.
AR 2011, Supreme Court 1436.
Yes, my lord. In my compilation, it will be in 26. The para 28 is in page 26.
Yes.
It has also been held that the magistrate in particular should ask the accused as to why he wants to make a statement which surely shall go against him, against his interest in the trial. He should be granted sufficient time for reflection. He should also be assured of protection from any sort of apprehended torture or pressure from the police in case he declined to make a confidential statement. Unfortunately, in this case, the evidence of the judicial magistrate does not show any such precaution was taken before recording the judicial confession, my lord.
Yes.
This is exactly the case, my lord, in which the appellant are poor and illiterate, and the confession was not done according to the, was not complied according to law, my lord.
Poor, illiterate?
Beg pardon?
Is it poor, illiterate?
Yes, my lord. I have already shown that illiterate and poor in page 17 of the paper book.
Yes.
In page 17, my lord, is
I got it.
in page 17, I have clearly stated, my lord, and have shown also educational qualification illiterate, my lord.
They mocked it.
And then income group also lower, below rupees 500 per month, according to the economic reform, my lord, is abject property. So they are poor and illiterate, and the law, there is no compliance with the law, my lord.
Yes. That's all.
And evidence also, there is not, no one point to us, my lord, to the appellant, my
You have
lord.
already said that there is no eyewitness. That's your argument.
No eyewitness,
The case is there is no eyewitness except confession. That is the argument. We have recorded it.
non-compliance with the law also, my lord.
And the investigation officer has also not taken photograph, etc., and not produced before the court.
And not done according to law.
Yes. All those points. Yes, sir. What's your case?
May it pleases your lordship. Lordship, the first contention of the appellant is that the charges have not been explained, your lordship. That, your lordship, is not correct, your lordship, because your lordship kindly come to the order framing of charges, your lordship. Lordship, the court, your lordship, say that lordship kindly come to page 27 that has been referred, your lordship, charge read over and explained to the accused. Lordship kindly, that is the type copy at page 27.
Yes.
Lordship, the court say that charge read over and explained to the accused by so and so, in language, accused so and so pleaded guilty, except one person, Dilip Sharma, your lordship. So, your lordship, all the accused except Dilip Sharma, your lordship, pleaded guilty, your lordship. Lordship, the learned trial court ought to have convicted the accused, but still the learned trial court had chosen to proceed with the evidence, your lordship. It has been explained, your lordship. It has been explained very clearly, your lordship. In my humble and respectful submission, your lordship, the court records, your lordship, are conclusive, your lordship. I cannot disbelieve, your lordship, the order passed by the learned trial court, your lordship.
Yes.
Then lordship kindly come, then because this case, your lordship, is based mainly on the confession statement. Lordship kindly come to page, the confession statement of this appellant, your lordship. Lordship will find it at page 96. page 96, Your Lordship. Lordship, the contention is that the procedure as laid down in section 160 been followed, Your Lordship. Lordship, at page 96, Your Lordship. That is the origin. Sorry, Your Lord, I'm sorry.
Yes.
Lordship, kindly come to page 96. That is the original record of the of the proceeding under 164, Your Lordship.
Page 96.
96, Your Lordship. Lordship, I'm taking Your Lordship to page 97.
Yes.
Can you see, Your Lordship? Having talked with accused, explained to him, Your Lordship, all this. Then, Your Lordship, can you see 5, Your Lordship? I now carefully explain afresh to the accused that I am not an officer of or police, but a magistrate that is not bound to make confessional, Lordship. All the procedure have, as laid down under 160, had been duly complied with by the learned recording magistrate, Your Lordship. Then, Lordship, kindly come to page 98. This is very important, Your Lordship. Lordship, a type copy is.
One substance of your friend's argument is that there are no eyewitness. We are repeating the same.
Lordship, yes.
No eyewitnesses.
Lordship, yes.
Then, except the confession, there is no other material before the court below.
Lordship, I'll point out to.
Wait, 1 minute.
Lordship.
You can reply. It's very easy for you to reply. Then he says that they are illiterates and they have not been informed in the local language about the consequences that may arise based on the admission that they are going to make before the magistrate. These are all the main submissions made by him. See, I think the judgment of Supreme Court in Bhagatram case and Chengareddy case, where the confession statement will have to be taken very carefully.
Lordship, in my humble and respectful,
of guilt.
in my humble and respectful submission, Your Lordship, if the confession is truthful, Your Lordship,
Sir?
if the confession is truthful, Your Lordship, then, Lordship, there is no legal bar, Your Lordship, to base the conviction on such confession, Your Lordship.
That is right. That is right.
Lordship, that I'll come to that, Your Lordship. I have brought a judgment on that, on Your Lordship. Lordship, kindly come to page 102, Your Lordship. That is the type.
No, you asked us to take page number 19.
Lordship, because there is a type copy, Your Lordship.
Or dash copy. Yes.
Type copy, Your Lordship. At page 102, Your Lordship.
100. Yes.
From where did the police arrest you? On what date and what time? My village on 11/7 at around 3 p.m. For how long you were in police custody? 1 night. What sort of behavior was given to you by police? Good. Did you understand that it's your discretion whether you make or the confession or not? I understand. Were you tortured or to were you tortured to make any confession? No. Do you understand that I am a magistrate? Yes. Even if you make a confession, you must know that you are not free or pardoned. The law will take its own course. Yes, I understand. It's very clear, Your Lordship. The confession is very clear. It's cogent and very clear, Your Lordship. The accused, the convict, Your Lordship, the appellant, Your Lordship, he knew, Your Lordship, the consequences. That what had been explained to him by the learned recording magistrate. Then, Lordship, kindly in para 7, Your Lordship, this his statement. Late Salong Rakait killed my mother when I was young, about 13 years ago, and we did not do anything because we were small and we just forget. But this man always picking up trouble with us, often when he was drunk, but most of the time we avoid and run away. Last week, during performance of family rites, he came to our house and started to create trouble, and we thought of finishing him, but the ladies did not allow us to do so because of our family rights. But again, on 10/7/2006, after he came from somebody's house, got drunk, and he came to our house and started to threaten the sister of the house, and at that moment, we Lordship. Kindly see, we, that means the present appellant, then Mud, Tum, and Julang came to the house and beat him. Then we pull him to the road and kill him with stick, stone, and hammer. After that, the ladies went and reported to the police, and the police came and covered the dead body. Lordship, the statement is very clear. There is a clear confession, Your Lordship, that we did, and nobody else, Your Lordship. We, Your Lordship.
There was a family problem.
We, that means myself and the other, Your Lordship, and nobody else, Your Lordship. Lordship, from the statement, it is very clear, Your Lordship, that it is a sort of revenge, Your Lordship.
Yes.
Then, Lordship, Lordship, can we come to the statement under 313, Your Lordship? What did he say to the confessional statement? Lordship,
How many are before this court?
3, Your Lordship. Lordship, one fact, originally there were 5 accused, Your Lordship. 2 died during the course of the trial, Your Lordship. That is Dilip Sharma, Your Lordship, who had declined to confess, Your Lordship, and 1 more died, Your Lordship. In the year 2018, they died, Your Lordship.
Both of them died in 2018.
Lordship, yes, during the course of trial, Your Lordship. The Lordship, kindly come to page 132, Your Lordship. That is the statement under 313.
Yes.
Lordship, kindly come to question 13 at page 136. Lordship, at page 136, Your Lordship, question 13.
One. Yes.
I'm reading it, Your Lordship. It also transpires from the evidence of PW7, that means the recording magistrate, Your Lordship, that your statement was recorded by him under 164 CRPC or so and so. What do you have to say? It is a fact. It is a fact, Your Lordship. I made a statement before the learned recording magistrate, confessing, Your Lordship, that I and the other have killed the deceased. It's very clear, Your Lordship. It's very clear that we did. We killed him.
Yes.
My humble Lordship, to conclude my submission, Your Lordship, the case of the prosecution is based mainly on this confession, Your Lordship. As I have submitted, Your Lordship, if the confession is truthful and cogent, Your Lordship, in my humble and respectful submission, Your Lordship, there is no bar, Your Lordship, in convicting. To that, Your Lordship, I would like to rely on the judgment of the Honorable Supreme Court, Your Lordship. Lordship, this, if Lordship is pleased to kindly come to paragraph 24 of this said judgment, Your Lordship.
Yes.
May I read it, Your Lordship?
Yes.
And now let us apply this test to the confession.
Which page?
Lordship, at paragraph 24, Your
24.
Lordship, yes.
Let me have also a copy, my lord.
Yes.
Lordship, this is 1978 3 SCC 435.
Copy undah.
Yes.
Lordship, because why I rely on the judgment, Your Lordship, because assumption has been made, Your Lordship, that near the court, Your Lordship, before the recording magistrate, there was a police room, Your Lordship. Lordship will kindly appreciate that this recording of the confession was made at that particular time, Your Lordship, when in the state of Meghalaya, there was no separation of the judiciary from the executive, Your Lordship.
Yes.
Lordship, I'll straight away, Lordship, I'll take to paragraph 35, Your Lordship, of that judgment.
And let me have the copy also, my lord, of the citation.
You should have a copy.
Yes.
Lordship, they did not supply me the copy, Your Lordship.
Supplied.
After
Okay.
coming here, I found the computer technology used better here. You can say outside is the best when compared to Chennai now. Madras High Court. Very good. By click of a button, we are able to see, we are able to operate from a residence. The same password, everything has been given. Very advanced. But all you can have, all of you will be having laptop, you are having a young junior,
Yes,
he'll be
madam.
having a laptop. By click of a button, you can go through it, see the judgment.
I am the
See, either that the voluntary confession can be accepted if it is not being properly rebutted. That appears to be his argument based on this citation.
Lordship, yes.
Correct?
Lordship, yes.
Yes.
May I read, Your Lordship, the judgment?
No, para 24 you start.
Lordship, yes. Para 34, Your Lordship, and then 35, Your Lordship, paragraph 35.
If you have a copy, give it to him.
Lordship, I do have.
How do you give this copy to your friend? I'll read it along with my brother.
Lordship,
I'll read it along with my brother. Not a problem.
I'm so. Yes, I do have, Your Lordship. I do have.
They have. Thank you, madam.
Same question paper. So copying is permissible here. Yes.
Lordship, kindly come to page, paragraph 35 at page 447. 447, Your Lordship. Paragraph 35.
447.
Lordship, paragraph 35 of the judgment.
Yes.
The evidence of the magistrate referred above show no more than the fact that the judicial lockup at Rising is located in a separate building near the police station. But from the mere fact that the judicial lockup is located in the proximity of the police station, it does not follow that both are under the control of the police. So exactly the case here, Your Lordship, because the chamber of the learned recording magistrate was near the police room, Your Lordship. Then Lordship, kindly come to para 39 of that judgment, Your Lordship. It is true that the interval between the preliminary examination of the appellant and the recording of his confession statement was about 15 minutes. But there is no statutory provision in section 164 CRPC or elsewhere, or even in that, even an executive direction issued by the High Court that there should be an interval of 24 hours or more between the preliminary questioning of the accused and the recording of his confession. The condition precedent for recording the confession by the magistrate in the course of police investigation is provided under section 164(2), which mandates the magistrate not to record any unless upon questioning the accused of a person, upon making it, he has reason to believe that is being made voluntarily, Your Lordship. That is what the learned magistrate has done, Your Lordship. He has put a question, has warned him also, Your Lordship, that there is a legal consequence if you make a confession. That has been done, Your Lordship. Then another judgment, Your Lordship,
I think there are two judgments, counsel. One is in Bhagatram case, the other one is Chinga Reddy or Chinna Reddy, some name is there. I don't remember now.
Lordship,
How,
if Lordship is talking,
weightage will have to be given to the circumstantial evidence. The confession.
maybe your Lordship is talking about this 1981 2 SEC 224. I have a copy of Lordship. Lordship, that judgment, I'm taking your Lordship to para 6 of that judgment. The final submission of the Land Council was that even if the confession to the major was accepted as voluntary, it had not been sufficiently corroborated to justify the conviction of the accused. It is now well settled that in order to sustain a conviction on the basis of a confessional statement, it is sufficient that the general trend of the confession is substantiated by some evidence which would tally with the contents of the confession. General corroboration is sufficient. So in the present case, the confessional statement refers to the motive of the occurrence. This part is corroborated by the evidence of PW1. This confessional statement refers to the accused having thrown a big stone on the head of the deceased. This part of the statement is corroborated by the medical evidence.
This judgment is not helpful to you.
Lordship,
This judgment is not helpful to you. Apart from the confessional statement, there are other materials.
Lordship, that is the Lordship, that is the statement of PW1, your Lordship, because PW1, your Lordship, she says that the appellant pull out the deceased from the house, your Lordship.
Right.
Then what happened, your Lordship? After he died, your Lordship, he was killed. So this is the link, your Lordship. This is also made a chain, your Lordship, the chain of circumstances, your Lordship, that they pull, your Lordship, of the house. And thereafter, your Lordship, he died. And in their confessional statement, the Lordship, they say that, yes, we hit him.
You are expecting us to draw a link, but link should be proper. Otherwise, it will be very difficult. See, the wife has also gone into the box and said that persons have dragged him out, and thereafter he died.
He died.
Not able to. That I think she was PW.
Yes, your Lordship. That is the evidence. The evidence speaks so, your Lordship. They pulled him, your Lordship. Then after he died, he died. And in their confessional statement, your Lordship, what did they say? We, that means myself and the other, we killed him, your Lordship. We hit him. And Lordship, also another aspect of the matter.
Yes, judgment reserved.
Lordship, so far that non-sending of the FSL, your Lordship, I have brought one judgment from the Honorable Madhya Pradesh High Court, your Lordship. Just because the investigation is perfunctory, your Lordship, that cannot be a ground, Lordship. I'm highly obliged, your Lordship.
Regarding that police matter, my lord, it is there in the admission of the PW7 also that he sent them to the PI, to the police. It is not that in adjunction to the place where he was recorded confession. He himself sent them to the PI, my lord. It is there, the PW7 are stated there in the cross. That may be noted, my lord.
Yes.
Obliged.
Thank you. That is it. Thank you. Much obliged.